Fourth Amendment to the United States Constitution. It provides protection against unlawful searches and seizures, but you know what? It provides more protection. Well, that takes us to this week's case. It involves a family in Champaign, Illinois, and there was a young woman named Kelsa Marco. Now, Kelsa was taking the family dog out for a walk. This was not a regular dog. This was a chocolate-covered Labrador, and a chocolate-covered Labrador that is a purebred Labrador. Ooh, very expensive dog. Well, anyway, she's taking the dog out for a walk when suddenly a stray pit bull attacks the dog, and the dog's name was Dog. Attacks Dog, and a brutal tussle takes place. It became evident to Kelsa and the other people who were there that they couldn't break this fight up, so they called the police. When the police officer showed up, Andre Davis, he saw what was going on. And at that point in time, Dog was getting a little better of the stray pit bull, and Dog was on top. The police officer couldn't see what was happening, and notwithstanding all kinds of pleas saying, don't shoot the chocolate-covered dog, don't shoot the chocolate-covered dog, it's being attacked. The officer shot and killed the chocolate-covered dog because the officer was colorblind. Well, when faced with the loss of this dog, the family was very distressed, very expensive dog, and they brought claim against the City of Champaign. They brought claim contending that their Fourth Amendment rights had been violated because there had been a confiscation of property without probable cause and without any compensation. So they brought claim seeking compensation for the confiscation of property. On the side of the City of Champaign, the attorneys argued no, nothing was done wrong. The officer showed up and he acted reasonably. He acted reasonably because he saw the fight going on and he used his best judgment. On the other side, on the side of the family, they argued no. Officer acted unreasonably because he knew people were telling him that the chocolate-covered dog was the dog being attacked, and he shot the chocolate-covered dog. And moreover, that shouldn't have been done anyway. Shooting the dog was last resort. He acted unreasonably. Okay, well, the case couldn't be settled. City of Champaign offered $10,000 to try and settle the case, but the family said no. Case goes to trial, and a jury hears the case. They hear evidence from both sides. And after they hear the evidence, the jury arrived at a decision, and they said, guess what? We find that the officer did nothing wrong. He acted reasonably. He showed up. He saw the dog fight going on. He said that he understood that one dog was attacking the other. When he got there, the dog that was on top appeared to be the attacking dog, and when the fight couldn't be broken up, that's the dog he shot and killed. Therefore, since he acted reasonably, we find that the City of Champaign, Illinois did not violate the Fourth Amendment, and therefore they owe nothing to the family. Okay. Well, what do we learn from this case? What we learn from this case is an important thing. Fourth Amendment is not just about unlawful searches and seizures. Fourth Amendment is also about seizure of property and confiscation of property. And in this instance, when a dog is shot, and a dog is property in the eyes of the law, the dog was confiscated, it was destroyed, and therefore the question is, did the city, a state agency in the sense of it was government, did the city act with probable cause? And the answer that the jury said was yes, they did, and therefore they owe nothing to the family. Okay, we bring you this case as we bring in cases every week so you understand how the law works. I'm David Allen.